Hi everyone, this is Heriot University's team for the RISM QS Virtual Symposium 2020. Our topic is Valuation of Variations and Provisional Sums. A private client has appointed our team as their QS consultant to advise them on the SOP for valuation of variations and the provisional sums as a formal contractual process for the company's adherents. The proposed project is a private development of a mixed commercial located in Kuching, Sarawak, and is procured using the traditional route. Therefore, PAM Contract 2018 with quantities will be adopted for this project and shall adhere strictly to all the good practices and conditions of the contract. What is valuation? The purpose of valuation is to appraise the work done to ascertain the amount to be proposed for payment by the employer. The QS must be aware of the overall position of any valuation within the project and assess what remains of the anticipated final contract value after each valuation and ensure that within the terms of the contract this will be adequate to complete the works. All variations shall be measured and valued by the QS. Upon completion of the variations, the contractor shall submit complete details and particulars as required by the architect and QS for valuation of variations. Where any recording of site information or site measurements are carried out at the site, the contractor is needed to provide the QS with such assistance as may be necessary. As stated in clause 11.5, if the QS is of the opinion that the details and particulars submitted by the contractor are insufficient to enable him or her to carry out the measurements and valuation, the QS shall within 28 days from receipt of the contractor's submission inform him of any deficiency in his submission and may require the contractor to provide further details and particulars. This will then allow the QS to measure and value the variations within 30 days or any other extended date as agreed between the architect and the contractor. What is variation? PAM Contract 2018 states that variations under clause 11.1 is defined as alternation or modifications of design, quality or quantity of works. The general approach for valuations is to require the architect to issue a formal instruction to vary the works. PAM Contract 2018 states that variations under clause 11.1 is defined as an alternation or modification of design, quality or quantity of works. The general approach for valuations is to require the architect to issue a formal instruction to vary the works. Valuation of variations are commenced by firstly identifying variation earlier before the architect issues instructions to the contractor on behalf of the client. The variations will then be discussed internally amongst the stakeholders such as the consulting QS, client and architect under the cost and budget meeting. Once an agreement has been made, they need to seek the client's approval for the amendments before the architect issues any further instructions to the contractor. Once the contractor reviews and evaluates the changes on cost and time implication according to PAM contract provisions, he will then need to notify the architect and consultant QS will need to check whether contractor's estimation is in line with their cost and time estimation or if it has exceeded. Consequently, the quantity surveyor will remeasure the actual quantities executed based on the rates and process in the contract document to determine the valuations as stated in clause 11.6f. Once everything is set to stone, commencement of work on site shall begin. Finally, contractor will be eligible for valuation claim once the value of work done under variations have been submitted with the support of documents such as AI, with the contract and construction drawing to identify the changes mentioned via addition or omission, revised BQ, RFV, RFI to be verified by appointed engineer as well as submissions of photos taken on site. RFV needs to be approved after architect issues instructions to the contractor, while RFI needs to be prepared before, during, and after work done. The QS consultant will need to conduct a site inspection to ensure all works are done according to specifications before approving the claim. However, there are few factors to take into consideration when processing claims. Claims will only be given to contractor once work done and all correspondents are approved. At the same time, there is a claim weightage given whereby 70% is given back to the contractor once architect issues a certificate of practical completion, whereas 100% is given when architect issues a certificate of making good defects. In the construction timeline, claims of valuations will only be done in the final account stage as it will be calculated and recorded with the rest of the work done completion. As indicated in clause 11.2, an architect may issue an AI ordering the variation or sanctioning any variation made in the construction project by the contractor where there is variation. The instructed variation order would not vitiate the original contract between the client and the contractor. Furthermore, the clause also enhances the contractor not to delay the execution of the variation order's works. If there's any pending variation valuation, the contractor needs to execute all variations that have been instructed with due diligence and expedition. These are supported by Raju, 2010, that the contractor must immediately conduct and complete the variation order works, notwithstanding any agreement on its pricing or valuation that the contractor has obtained the valid AI. The issuance of variation must be made in writing with the architect. The architect may issue such instructions at any time as may be required prior to the issuance of the certificate of practical completion. It is mentioned that even though the contractor is liable for delay and a certificate of non-completion has been issued previously, variation order still can be issued. Any variation order instructed after the achievement of the completion milestone would not be contractually binding with the contractor and will not comply with such instruction unless there is an express clause in the contract authorizing such order of variation to be given. In addition, if there is any variation instructed in AI, it needs to be a consequence of obligation or compliance with the requirement of any appropriate authority and service provider. This is the variation works that cannot be measured and valued. This is the SOP for valuations of provisional sum. Firstly, the contractor will provide a schedule of quotations to the QS. If the quotations are sufficient, then the QS must measure and value the variations within 30 days and the finalized quotation is forwarded to the client for approval. However, if the quotations are insufficient for the QS to carry out measurement and valuation, the QS must request for further details within 28 days of the contractor's submission. Then, the contractor must provide the requested information within 28 days of the QS's inquiry. Furthermore, the provisional sums are valued by the QS according to valuation rules provided under Clause 16. For example, if the work done by the contractor is similar in terms of the quality and the quantity and does not have significant change from the promised work stated in the contract, then the QS will valuate according to the rates and prices as stated in the contract. This also was mentioned in Clause 11.6a. The contractor's entitlement for loss and expenses is as follows. An epidemic is one of the events which is considered as force majeure under Article 7 of PAM Contract 2018. The clause is as follows. In relation to the pandemic, this clause is applicable for the contractor to rely on claiming extension of time. Nevertheless, the contractor must be proactive and take necessary steps to ensure EOT is granted. The procedure for loss and expense claims are as follows. In the event that the contractor has a basis to claim under the list stated above, the contractor is to submit a written notice within 28 days from the date of issuance of AI, or the day of the above matter occurred to indicate their intention of claim. Supporting documents must be attached with the initial estimated claim amount, construction drawings, relevant letters or emails, and the calculation presented. Failure of contractor to submit the necessary particular within the time frame signifies their rights for loss and expense claim has been waived. Hence, the contractor must bear the cost on its own expenses. Firstly, under the PAM Contract 2006 and 2018, a written notice supported with evidence such as the affected work progress and a rough estimation of time required must be issued to the project architect. Once the justification from contractor is accepted by the EOT committee, certificate of delay and EOT will be drafted and signed by authorized parties. If the reason is invalid, the SOR will issue a warning letter and state its intention to issue certificate of non-completion, which may result in liquidated damages. Nevertheless, MCO falls under force majeure and the contractor is entitled to claim for EOT if necessary steps are taken within time. In this case, the contractor must file claims supported with evidence within 28 days of the commencement of MCO. This means the contractor must notify his intention to apply extension of time with a solid basis in reference to clause 23.1a and gather the adequate information to allow the architect to assess the duration for EOT, which is stated in clause 23.1b. Subsequently, within 28 days before the end of MCO, the contractor must send the final claim to the architect. However, the actual situation of extension of MCO, there may be possible multiple final claims sent to the architect. It is also important to note that under clause 26.3, the contractor has a duty to prevent and reduce delay of work progress with the best of its ability. Failing to do so shall amount to a breach of duty. To apply MCO scenario in the context of valuations of variations and provisional sum, valuations on site may be delayed as MCO prohibits all work on site. This means that the cycle of valuation, applications, and certifying the valuations will be delayed. Although extension of time is indeed provided to the contractors, the client has no obligation to ensure the contractor has a healthy cash flow and required to pay in advance as loss and expense is not entitled as a result of force majeure. In line with the new mandatory SOP of ensuring the health and safety of workers, sanitization and additional PPE will incur costs to the contractor. There are no provisions to allow contractor to claim such cost incurrence from the client. Regardless, the government has provided subsidy for the construction companies. Amidst the pandemic, contractor and client must work together to reduce costs, risk, and time in ensuring a successful project delivery.